Good afternoon, everyone. Welcome to the intense course on media literacy for students. It is a collaborative venture between Adamas University, Kolkata and Delhi Metropolitan Education, Noida. It is a first of its kind initiative in the country for creating better society and vigilant youth. The course constitutes of 12 sessions and 18 hours. The sessions are jointly conducted by resource persons from Adamas University, Kolkata and Delhi Metropolitan Education, Noida. The collaboration is helmed by Professor Ujjwal K. Chaudhary, Pro Vice Chancellor, Dean, School of Media Communication and Fashion, Adamas University, Kolkata, and Dr. Amrish Saxena, Dean DME Media School, Director DME Studios and Production, Delhi Metropolitan Education, Noida. The objective of the course is to impart essential skills that enable students to make sense of media messages and creation. We have by now learned about the basic of media literacy, importance of media literacy in the contemporary society, the different types of media and their challenges, how media functions, the ownership patterns, how gender and race is represented in media, how to become an active user of media, how context changes the content and the navigation of safe information online. One of the primary objective of the course, apart from making students media smart, is to make them a responsible citizen who can objectively make a decision in the electoral process. To guide us with the process, we have with us Dr. Amrish Saxena. He is an accomplished media professional, researcher, author, anchor, and political analyst. He has worked at different media platforms ranging from theater, puppetry, print, radio, television, films, and digital before switching over to media, academics, and research. Dr. Saxena has played a long inning in active journalism, having associated with groups like the Pioneer and Amrit Bazar Patrika during 1980s. He has worked as a correspondent for the first ever TV Hindi news magazine Parak on Doordarshan during 1990s. He has been anchoring the highly rated program of AIR FM Gold Market Mantra for close to 2 decades. Dr. Saxena has academic association with more than 20 universities, which include 4 central, 5 state, and 9 private deemed universities. He has 36 books to his credit as sole author, main author, chapter writer, and editor. He has presented more than 60 research papers in national and international seminar conferences. Dr. Saxena has extensive international exposure. He has visited China, Australia, United States, Dubai, Egypt, Spain, France as a part of his academic endeavors. He is member of International Association of Media and Communication Research, IAMCR. In 2019, he made a presentation on innovation in journalism education as the sole representative of Asia in World Journalism Education Congress in Paris. I'm sure along with students, I am also going to learn a lot from you today, sir. Over to Dr. Asha.
I do agree with Ms. Yashashvika that I am also looking forward to this session to learn. Today's session is really important because it is about law, and it's a specific set of laws and regulations which we should be aware about and which we should know at least all of us should know, not just media students, because it is important as citizens and future citizens to know about our legal rights and legal frameworks. So I, without any further delay, would like Dr. Amrish Saxena to start his presentation. You're welcome, sir.
Thank you. Thank you, Dr. Asha Singh. Thank you, Yashasika. So thank you for all those who have joined this session to participate. Now, as far as the topics which have been assigned to this session, obviously the subject becomes very, very vast. Media laws and ethics, if we look at the complete thing, then we need hours and hours to take up different topics. And at the base of everything, whether we say media laws or laws as such or the Constitution of India, I believe that there are certain basic things which everybody must know, irrespective of the fact whether somebody is a student or is an ordinary citizen, must be in any occupation, any business. But then there are certain things which everybody must know about Indian Constitution and Indian legal system. And the first and the foremost thing is right to freedom of speech and expression. There is a chapter in the Constitution, Chapter 3, which comprises all these fundamental rights, which is starting from Article 12 to Article 32. Number of rights are there. Maybe that for any common person, maybe it's difficult to go through and every fundamental right and to understand what all has been talked about. But then at the foundation of all the fundamental rights is the right to freedom of speech and expression. Now, so I will start with this, and obviously when I am talking about this, then I have to talk about the reasonable restrictions on the freedom of speech and expression. And then there are two more laws, which are defamation and contempt of court, which are in a way part of Article 19.2 as well. So that need to be covered. And then I would also like to touch upon sedition, because that is again directly, indirectly part of Article 19.2, and finally the copyright. So this whole plate is full with so many things, but then I will try to give the basic understanding, because given the time constraint that we have in this course that we have started on media literacy, already we are having 12 sessions and more than that was not possible. So to start with, this right to freedom of speech and expression. Now, the basic right, if I talk about, the basic right is about freedom of speech and expression. And if we talk about freedom of speech and expression, then there is one right which is in a way a right derived from this right, which is right to freedom of press or freedom of media. So the first thing which I would like to tell everybody in this session, that these two rights are the same, because the student they might be studying certain part of whatever I am telling in this session in this political science subject. But then the first thing, so this Article 19.1a, this is right to freedom of speech and expression. And in our constitution, there is no separate right which we can call the freedom of the press or freedom of the media. And there are two types of models as far as the constitutional democracies in the world are concerned. One is our constitution, which is basically we have been following the legacy of the British, and that is how we have not separately incorporated a right for the freedom of the press of media, unlike the US Constitution, wherein a separate mention is there for freedom of the press. But I believe for the beginners, it is not of much relevance whether it's a right which is mentioned in the constitution or not, because the way the Indian constitution have been framed and the way it has been functional for the last 70 years, there have never been a problem on this count, that and never anybody was compelled to think about this, that had there been a separate right or not. But then this is essential to understand that press in India does not have a special right. This is necessary to understand for all those participants in this media literacy course, because we normally believe too much on media. I'm not saying that don't believe on the media content, but then you should always be is capital of the fact that not everything which is there in the media is to be believed. And in today's time, particularly, we have been talking about different components of media literacy. And since this whole course is about understanding at what all misinformation or malinformation, disinformation is being carried on the social media, and whether that is to be believed or not. So my caution to all the participants will be, whatever contents are there, whether on the mainstream media or on the social media, never believe all those content for the reason that there is something which has appeared in the newspaper. All newspaper persons, all journalists, they have the same right as we as common citizens have. right? Now, this is one. Another important thing which we must understand about the elements of this freedom of speech and expression. This right can be exercised only by a citizen of India. This means no foreign national can make use of this. And what all is included? Any kind of expression, whether we are making an oral expression or a written expression, or something is being said, something is being painted, something is being picturized, everything is covered under this freedom of speech and expression, which is part of Article 19(1)(a). So moving on, we must look at that what all is covered under this right. Now, one thing must be understood. Not everything can be mentioned in the Constitution, and not everything is there in our Constitution. There are certain things which we can understand either in the written form, which is there in the Constitution, or we can also refer to the constitutional and the debates of the Constituent Assembly. They are as good as whatever provisions are there in the Constitution. So now we have to look into that. What I mean, how can we protect our these fundamental rights, including this right which I'm talking about? So the state means the government is there for the protection of this right of the citizen, all the fundamental rights of the citizen. And suppose if the government fails in protecting our rights, then we can move to the Supreme Court or any of the high courts, and we can file a writ petition there. If we are filing a writ petition in the Supreme Court, that will be covered under Article 32. And if we are doing this in any of the high courts, that will be covered under Article 226. Now, moving on, I must tell you this, that whatever is written in the Constitution, beyond that, if we try to understand what is the meaning of whatever is written in the Constitution, now for that interpretation, we have the Supreme Court of India. Supreme Court is in fact is a body which does number of things, uh, particularly the constitutional review, which is a very sacrosanct power of the Supreme Court of India. And then any ambiguity, if that is found in any provision of the Constitution, then obviously Supreme Court is there to clarify and to interpret what is the meaning of all that which is there in the book of the Constitution. So I will in very brief talk about some of the important cases which have been decided by the Supreme Court, and which are in fact a commentary of the right to freedom of speech and expression, and all essential interpretations we find in different cases. There are a number of cases. I have selected only 4 or 5 cases to tell you about. Now, another thing, what is the meaning of interpretation? Any case which is there before the court, there may be the Supreme Court may be requested to make the interpretation of something, or may not be the case. But if something is there before the Supreme Court and judgment is being given by the Supreme Court, then the interpretation is in a way part of the judgment. And any judgment which is there made by the Supreme Court, then for all future purposes, that is considered a part of the Constitution, or that is considered an extension of the Constitution. So if I talk about the first 2 cases, and interestingly, these 2 cases happened the year the Constitution was put into implementation. The Constitution was implemented in January 1950, and then the same year these 2 cases happened. The first case is Romesh Thapar versus State of Madras. The other case is Brijbhushan versus State of Delhi. Now, telling you in 1 or 2 lines about these cases, because these are very landmark cases, and these form the foundation of whatever we are trying to understand in this session particularly. Now, if we talk about the Romesh Thapar case. Now, Romesh Thapar was a printer, publisher, and the editor of a newspaper, Crossroads. It was a weekly which was published from Madras. Now, this newspaper was critical of the then government, which was headed by Pandit Jawaharlal Nehru, the then Prime Minister. So now, mind it, there are certain things which you must understand very cautiously. The first government that was of Jawaharlal Nehru, and we all understand that he was a votary of the freedom freedom of the press. But interestingly, in this first case, he did not like the kind of criticism which was being done by this newspaper. Now he could not do anything straight, so he wanted to teach Romesh Thapar a lesson by taking a step which was from behind the curtain. So that time, in every state there was a Congress government, and this Madras government minded the present state of Tamil Nadu. The earlier name was Madras. The state was named as Madras initially since the British time, and the capital of the Madras was also the Madras. So what Ramesh Thapar did, he sounded, sorry, what Jawaharlal Nehru did, he sounded the state government of Madras, and Madras government put a restriction on the circulation of the crossroads in the state of Madras. Now, Romesh Thapar went to the Supreme Court against this order of Madras government. Supreme Court struck down the order on the ground that it is violative of the freedom of speech and expression, that is Article 19(1)(a). Now, what is the interpretation? What is the one-liner, that what is the takeaway from this judgment? The takeaway is that freedom of speech and expression comprises freedom of the press, and freedom of the press comprises freedom of circulation of the newspaper, because without circulation, whatever is published in the newspaper, that freedom is of no meaning. Now, the other case, that is Braj Bhushan case versus State of Delhi. The background to this is after the India got independence, there were a lot of communal rights happening in different parts of the country. In Delhi also, communal rights were happening, and Braj Bhushan was in fact the publisher of and the editor of a newspaper, which is called, which was a mouthpiece of the RSS, and the name of the newspaper was Organizer. So this newspaper was publishing all sorts of reports, which the Chief Commissioner of Delhi found are violative, are in fact obstructing the law and order in the state. And so he issued an order to the organizer that anything which is to be published in the newspaper has to have the clearance of the government. Brij Bhushan went to the Supreme Court against this order. The relief was provided by the Supreme Court, and it struck down the order issued by the Chief Commissioner of Delhi on the ground that no pre-censorship is possible. Now, this is the backbone of the freedom that we enjoy in our country, that any media organization, whatever contents it is disseminating, it's publishing, the state has no power to preview it, to pre-censor it, or the censor it. Now, mind it, this is something which should be related to 2020, the situation that we have. Whether we talk about the mainstream media or we talk about the social media, the government has limited powers. The government cannot stop any information to circulate till the time there is a violation of the existing legal system in the country. In the first place, the government cannot interfere. The government cannot put a blanket ban on the circulations of some information, because pre-censorship is not allowed. Another case is this Indian Express versus Union of India. This is a case which tells us that media persons and the media organizations, they do not enjoy any immunity from the laws of the land. What does it mean? The background is there was a law which was passed by Parliament. This is called Working Journalist Act 55, which was amended in 1957. Now, in this law, the Indian Express went to the Supreme Court that if we implement this Working Journalist Act, we will be under financial trouble. But the Supreme Court did not agree from that argument, and Supreme Court said that whatever laws are made by the Parliament, they have a binding impact, and everybody has to go by it. Even if there is a newspaper organization, they cannot evade implementation on a law. Another case which is important is Sakaal Newspapers versus Union of India. This is a 1961 case, that time on the basis of a recommendation of the First Press Commission. The government came out with a law which is establishing a relationship between the number of pages and the pricing of a newspaper. Sakaal newspaper objected to this, approached the Supreme Court. Supreme Court struck down this law on the ground that the government cannot put any restriction on the fundamental rights which are covered under Article 19. So there are two laws which were being violated by a law passed by Parliament. And the first law is this only, freedom of speech and expression, Article 19(1)(a). And the other law is 19(g), which is about having, I mean, every citizen in the country is free to have any occupation or business, and the government cannot control it. And the final case which I will be talking about is Khwaja Ahmad Abbas versus Union of India, 1970. Khwaja Ahmad Abbas was a filmmaker, and many of you, I believe, would have seen his films that he made. He was a filmmaker with a left orientation, and he was the one who gave Amitabh Bachchan the first film in his career. And he went to the Supreme Court against the provisions of the this censorship, which is, I mean, there is a law which has been passed by Parliament, that is Cinematograph Act, and as per the provisions of this act, there is a provision of Central Board of Film Certification, which we commonly call the Censor Board. So and there are guidelines prescribed by the Censor Board, and if I mean, and any film which is made has to be previewed by the Censor Board, and if the Censor Board finds that there are certain things which are not as per the guidelines prescribed, then the Censor Board can ask the filmmaker to make the amendments. Khwaja Ahmad Abbas challenged this in the Supreme Court on the ground that if this is a law, I mean, if this kind of provision is there, then why there is no press censorship in the print media? So he said there are dual standard in print media. There are no pre-censorship or censorship, but in a way, preview means the censorship, and in cinema, this pre-censorship are there. But Supreme Court said that this censorship must be allowed and must be covered under Article 19(2). So now moving on to Article 19(2). I told you about 19(1)(a). What is 19(2)? 19(2) puts restrictions, reasonable restrictions on the freedom which has been covered, which has been granted under Article 19(1)(a). Now, what are these reasonable restrictions? You can see it on your screen. These restrictions are security of the state, friendly relations with foreign states, public order, decency and morality, contempt of court, defamation, incitement to an offense, and sovereignty and integrity of India. Now, one interesting thing I must tell you, when the Constitution was made and implemented in 1950, there were only 3 reasonable restrictions. This means the rest 5 restrictions have been added later. Another more important thing is that when this first case on freedom of speech and expression was decided by the Supreme Court, that is Romesh Thapar case, the government of that time, as I told you, that Pandit Jawaharlal Nehru was not happy the way he was being criticized, and he was trying to keep a control on newspapers. So the first constitutional amendment in Indian Constitution happened in 1951 only, wherein 3 reasonable restrictions were added under Article 19(2). Now, what does it mean? If we try to understand the meaning of this, even in 2020, this means that no government is ever comfortable with the freedom of speech and expression, whether we talk about the Jawaharlal Nehru's government or whether we talk about Narendra Modi's government. Every government is apprehensive, is scared of the freedom that is enjoyed by media. So as young students, you must understand that freedom of speech and expression is a very pious thing, and we all must make sure that we enjoy this freedom, but at the same time, we are not misusing its freedom. And also, we should never let the government allow to take away this freedom, because this is a freedom with which which we have the existence. If this freedom is gone, the democracy is gone, the constitution is gone, the country is gone. So we must fight for this, that we must enjoy this freedom, we must possess this freedom, and we should not allow anybody to take away this freedom. Now, to tell you in one line about these provisions which are there under Article 19.2. Now, what is the security of the state? Is that anything which is hampering the security of the state is not allowed. It's not covered under Article 19.1a. This friendly relations with foreign countries is a very ambiguous provision, because, say, for instance, if India has friendly relation not friendly relation with Pakistan and China, and I can give you a very live example, very recent example. What happened recently? A news website, they published the interview of Chinese ambassador in India. Sorry, not the website, but it's, I can even name the agency. There is a news agency, Press Trust of India. It carried an interview of the Chinese ambassador in India, and the government took in a way took revenge from PTI, and they put a restriction on Prasar Bharati. Mind it, though Prasar Bharati is an independent organization, but the government does a lot of things from behind the curtain without any sanctity, without any legal authority. So what happened? The government asked Prasar Bharati to discontinue the services of PTI, which means a financial jolt to PTI to the tune of approximately 10 crore rupees in a year. So this means how the government acts to crush this freedom. That must be understood. And if you understand this, that will make you more vigilant citizen. And you must understand that you should always be up in arms to protect your freedom, even if the government is trying to take away this freedom. And that will make you a responsible citizen. And if you are trying to protect your freedom, at the same time, you must understand you should not take away the other person's freedom. This is what is very, very important in the case of the social media. We are enjoying every freedom, but at the same time, we try to pull somebody, we try to suppress somebody's voice, and then we find no wrong in that. That should not be done. That's the caution which I am trying to give you here. And then public order. Public order means, say, for instance, if there's a communal right or any such thing, then the government can put some orders, and in that case, some prohibitory orders, and in that case, your freedom of speech and expression guaranteed under Article 19.1a will be taken away. Now, as far as decency and morality is concerned, this is very interesting to understand. What is decency and morality? This is a very subjective thing, because this morality or the moral values of the society differ from one society to another. Our value system is different as compared to any country of the Europe. Within our country, there could be a different kind of social values or the moral values which apply to the people who are elite, who are living in urban areas, to the people who are living any tribal community living in a remote area. So there is no definition of this, and that is how this is something which is always misused by the existing governments. Now, about contempt of court and defamation, I will not touch upon these two things at the moment. After 5 minutes or so, I will take these two things, contempt of court and defamation, in a much elaborated manner. Now, incitement to an offense. Now, this is something, if I again relate it to the social media, because we all use social media, you people must also be using it. What happens? There are number of mob lynching which have happened in different parts of the country, right from this Palghar incident which happened in Maharashtra, then one incident last year, I think in the beginning of this year only, it happened in Assam. So if we are using the social media for spreading rumors, and because of this some violence happens, some killings happen, that can always be treated as contempt as incitement to an offense, and this is not part of your freedom. This is covered under reasonable restrictions under Article 19.2. Now, the final thing, sovereignty and integrity of India. We all understand sovereignty means that any state is a political term, means that any government has a sovereign power to rule the country, to make laws, to decide policies, and even within the country, nobody has the powers to come into this way and to challenge the integrity of India. Like a lot of hue and cry is happening. If I can refer to the latest case which happened 2 days back with regard to the statement given by the former Chief Minister of Kashmir, Mehbooba Mufti. So these are the issues where in the government can come into the picture. And in the case of the Mehbooba Mufti's statement, there are demands continuously that case should be registered against her under the law of sedition. So I will also touch upon this sedition law under this sovereignty and integrity of India. Now, for moving fast towards this contempt of court. Now, contempt of court is covered under Article 19.2. Also, there is a law which has been made by Parliament, a legislation passed by Parliament under Contempt of Court Act 1971. Now, one very important thing I must tell you here, that whatever laws are made in our country, if there is a law which is in harmony with the constitutional provisions under Article 19.2, if I put it the other way around, whatever provisions have been mentioned under reasonable restrictions under Article 19.2, or if the government wants to include anything under this 19.2, so a constitutional amendment has to be brought. And as per the existing reasonable restrictions, no reasonable restriction can be implemented without the support of a legislation that would have been passed by Indian Parliament. So here is one example. Their contempt of court mentioned in 19.2, and to give effect to contempt of court under 19.2, a law has been passed by Parliament, which is this Contempt of Court Act 1971. Now, there are two types of contempt of court. One is a civil contempt and another is a criminal contempt. And what is contempt? Contempt is that if by any act, any citizen, and even, I mean, journalists included, any media person is coming into the way of the functioning of the court in any way, whether you are showing disobedience to whatever the Supreme Court would have ordered, or any court, High Court would have ordered, or you are showing disregard to the court, or you are creating some kind of obstruction in the delivery of the justice system, then the Contempt of Court Act, the provisions of this act will apply. Now, coming on to the next slide. Now, firstly, to tell you about the civil contempt. What is civil contempt? Civil contempt is wherein you are not following the orders or the instructions or the judgments of the court, High Court or Supreme Court or whichever court, or you are doing it deliberately. You are doing it deliberately, then this will be part of the civil contempt. And if you are creating an obstruction in the justice delivery system, then you are involved in criminal contempt. Now, to moving on to the next slide, if I can tell you something more about civil contempt. And I can tell you some very interesting cases wherein you will understand the objective of civil contempt in the contempt case is not to give punishment to the offender, but to make that person understand that if there is some disrespect is being shown to the judiciary will make you understand the sanctity, the importance of judiciary in our democratic system. So this one important case, that is of Kalyan Singh. Kalyan Singh was the chief minister of UP when this Babri Masjid structure was demolished. And during that time, in this case, which has been very recently decided by the Supreme Court with regard to the title of the land on which Babri Masjid structure was there. So in that case, the Supreme Court asked Kalyan Singh that given undertaking in the Supreme Court, that till the time the Supreme Court gives its judgment, there will be no damage to the structure. So Kalyana Singh gave this in writing in the Supreme Court, but thus in 1992, the structure was demolished. A case of contempt was brought against Kalyana Singh, though he was no more chief minister of UP till that time. But in 1994, he was sent to 1 day imprisonment. Now, this is civil contempt. Only token punishment is given, and only very minor financial punishment is given in the case of the civil contempt. Another case is that of related to the this height of Sardar Sarovar Dam. Sardar Sarovar Dam in Gujarat, and on this river Narmada. Now there was a movement that is called Narmada Bachao Andolan, and the people in this movement, they were opposing firstly the construction of this dam, because after this dam has been constructed, a lot of land in Madhya Pradesh has this fertile land, the agricultural land has got affected because the whole stream of the river has been in a way narrowed down, has been stopped in Gujarat. And when Gujarat government wanted to raise the height, this Narmada Bachao Andolan opposed, but finally Supreme Court in its judgment allowed the raising the height of the dam to 138 meters. There were sharp reactions from the activists of the Narmada Bachao Andolan, and Arundhati Roy, who is a famous writer, she criticized Supreme Court for making this kind of judgment. Initially, the Supreme Court cautioned Arundhati Roy, but she did not stop. She was very critical and very harsh on the Supreme Court. Finally, Supreme Court called her to appear in person before the Supreme Court, and finally she was sent to 1 day imprisonment. Right. So now this is the civil contempt. Now talking about the criminal contempt. Okay, so moving on, Ritik, to the next slide. So talking about the criminal contempt, now this is very serious in nature. And what kind of acts would amount to criminal contempt? Suppose as a journalist, you publish the interview of a witness who is supposed to be presented or who is supposed to be examined and cross-examined in some court the same day or the next day. This means you are in fact taking I mean snatching the right of the judiciary, which is there for examining the a witness. So this is an infringement in the rights of the judiciary. So if you try to scandalize the Supreme Court or High Court or any court for that matter, like if you raise a finger on the integrity of a judge, or if you write this that some judge is incompetent, not is incompetent to make a judgment, or if you write this that there's some corruption involved, and this, or if you write any such thing as a journalist or otherwise on the social media as a common citizen, you write that this judgment has made so and so judgment because of some consideration, whether the money, whether the caste, whether the religion, the judge might be making a judgment in favor of the people who belong to his or her caste, then this amounts to criminal contempt. And there are severe punishments for this. As far as the next slide, please. As far as the punishment is concerned, in terms of monetary punishment or in terms of jail. Now, moving on, as I earlier told you this, yeah, there's one important case that I must tell you in brief. There's a Justice Karnan. He was in initially Tamil Nadu High Court, and he, because of some complaints against him, he was very, very vocal against whatever wrongs were happening within the judiciary. We do not know whether that was whatever points he was raising, those were right or wrong, but he was doing this all. So he was transferred to Calcutta High Court. There he wrote to the President of India, to the Chief Justice of India, against 20 judges, and he said that these judges are involved in corrupt practices. The Supreme Court took serious exception to this, and a case of contempt was brought by the Supreme Court of India against a sitting judge of High Court. This is the most unique case of its kind. The case was heard by a five-judge bench by the of the Supreme Court, and JSKR was the Chief Justice of India. And finally, the orders were issued for the imprisonment of this Justice Karnan. Justice Karan was about to retire in 2017 when this judgment was made by the Supreme Court. And he was arrested after that for various charges, including the criminal contempt of court. Moving on, next slide. Now we move on to defamation. As this contempt of court is mentioned under Article 19.2, defamation is also mentioned under Article 19.2, the reasonable restriction. There are some very interesting things about defamation that I must tell you before reading out or whatever has been mentioned in the slides. Now, this again, defamation has two types of defamation. One is a civil, another is criminal. But interestingly, there is no civil law for defamation in our country. If we look into as to what amounts to defamation, we had to refer to its definition. And this definition has been given under Section 499 of Indian Penal Code. That's the criminal law. So definition is under the criminal law, and the same definition applies to the criminal offense and as well as the civil offense. Civil offense in a way is covered under law of torts. Law of torts is in fact works on the precedents. So, but then there is no codified law as far as the civil law of defamation is concerned. So you can see the definition of defamation on the screen. So anything which is expressed, which is written in any form by making use of any medium, maybe the signs and the symbols, the visible representations, or I mean, any such thing is there. Even if you are making a drawing, making a sketch, or even if you are nodding or you are making use of any such expression, everything is covered under the law of defamation. Now, moving on, and this is covered under 499. Now, here also, like the contempt of court, this defamation is of two types, the civil defamation and the criminal defamation. And broadly, we can cover this under two categories. I mean, what amounts to defamation? So as I explained that if by speech means anything which is said, which is part of the oral communication, and anything which is written. So broadly, these two areas. Now, under the law, these two areas are covered under two different category of defamation law. One is called slander and another is called libel. Slander is with regard to oral communication. A said something about B. A newspaper publishes something about a politician. Now that will be part of libel because that is in the written form. So libel defamation covers something which is visible, which is seen, which is written. So all kind of cartoons, pictures, symbols, caricatures, posters, everything is covered, or I mean, referring to the television channel, television news channels, anything which is seen on a television screen is part of libel. And uh, uh, and anything which is published in a newspaper, that is also part of the libel. But anything which is spoken by a news anchor will be part of slander. Anything, the tickers which you would have noticed are coming on the screen, they are part of the libel. So legally, these are the two different sets of laws. But then, for the common purpose, there is hardly any difference. I will tell you some very small examples so that you can make out. Say, for instance, something is published in a newspaper, and the person against whom something has been written takes offense to it and decides to bring a case. Now, there will be a case of civil law and civil law, and which is libel, written communication. But if based on that a story is carried by a television channel, and the news anchor is saying something that such and such report has appeared in such and such newspaper about such and such person, that will amount to slander, because that is part of the oral communication. But then whatever is being said by that news anchor, if the same thing comes as a captions, as a subtitles on the screen, which is in the written form, so that will amount to libel. So there is a thin line that way between slander and libel. Now moving on, slander is part of the civil law, civil offense, and as I said already, libel is part of the criminal law. Now what is the defense? Defense means if a case is brought against somebody, against a journalist, now journalist has a right to defend. How can he defend? So that I will tell you. And if suppose you are on the social media, you write about some politician that he is corrupt, now he can bring a defamation case against you. So you should be alert whenever you are writing something on the social media, that you can get yourself indulge into a violation of law, that is the defamation law. And once you are trapped, now how can you save it? So there are two things through which you can save yourself. In the case of libel, you can save yourself by establishing it in the court of law, that whatever you have written, whatever you have said, that is true. So truth is a defense in the case of slander. In the case of libel, in the case of some written material. So if you are doing something on the social media and that is in the video form or in the audio form, then you will be trapped under slander. And if you are writing something, any opinion that you are expressing on the social media, for instance, this means you are involved in libel, and the only defense which is available is good faith. Like the Bihar, in Bihar the elections are happening these days. So for instance, if you write about some political personality who is participating in the Bihar election, about his corruption or any such thing, and if a case or defamation is brought against you, how can you save yourself? You can save yourself by writing this, that you had done it in good faith. You had no intention of defaming that politician. But what the politician will do to establish case against you, he will say this, that you have timed your action. So your intentions are wrong. You did not do it in good faith. So he will doubt on your intentions. If he succeeds, then you are in jail. And if you are able to prove that you have done it in good faith with no malice intention, then you are saved. Now, moving on in defamation. Now, as far as the defamation is concerned, as I explained already, there are a few more things. Anything, any imputation, either directly or indirectly, which lowers the moral or intellectual character of an individual, or is believed to lower the respect of that person in the caste or religion, so that will amount to defamation. But there is an interesting thing which I must tell you here. Defamation means lowering of the reputation of a person. What does it mean? That that person has to have the fame. That person has to have the reputation. This means only the famous person can bring a case against you for their defamation. And how it will be decided? What is your fame? What is your fame? What is your reputation? This is decided based on the socio-economic profile of a person. This means if a person is a respected person in the society, by way of his deeds, by way of his work, or if there is a person who is occupying a public office, who is on a senior position, who might be a very successful businessman. So in that case, the case can be brought against you. But no poor person can bring a case against somebody because that poor person does not have a fame. This might be, might be very, very, interesting this kind of law exists, and that is why there is a criticism of this law, that this is a law which is for the elite section. And if we look into the cases for the last 70 years, the cases which have happened, this is a law which is being mostly misused to settle scores with the opposite party, and mostly politicians use it. But then, as a common citizen, you all must be beware of this. That if you are doing this and somebody wants to teach you a lesson, that why have you written something against that person, maybe right or wrong, this is something which you have to establish in the court to save your skin. You have to prove that whatever you have written is true, and you have to substantiate it. But if you are not able to do that, and somebody is annoyed with you, and if somebody brings a criminal case, criminal defamation against you, then you will be behind bars. Now, as far as the remedy is concerned, that also must be told to you in the case of defamation. If somebody brings, for instance, if somebody brings a case of civil defamation against me, this means I might be compelled by the court. If the court finds that I have done that, I might be compelled to pay a handsome amount to the party who has brought a case against me, and that will be part of the civil contempt. But if somebody wants to teach me a lesson for the things that I have written against that person will not bring a civil case against me. He will bring a criminal case against me. And if that case is proved, then the punishment is I have to go to the jail. So this means lot depends on this, that what the person wants. I mean, the person who feels that his defamation has been done. If that person wants to teach me a lesson, to see me behind bars, he can always do it by bringing a criminal case against me. If that person wants to extract money from me as damages for the loss of his reputation, he will bring a civil suit against me, and he will ask me to pay 5 lakh rupees or 10 lakh rupees to the court. And if the court gives that kind of verdict, I have to pay the amount. So this means the person who is bringing a case of defamation against me has to decide whether he wants to bring a case of civil or criminal minded. The person concerned who feels defamed can bring a civil case against me, can bring a criminal case against me, can bring both the cases, civil and criminal, simultaneously, or one after another. Right? But then the person has to be sure that he will be able to prove the case. And in that case, I have to be sure whether I will be able to save my skin or not. Right? And another important thing in the definition, which I explained, that defamation has to be in the eyes of the substantial number of people. What does it mean? This means A abuses B. And in the room, only A and B are there. And if B decides to bring a case against A for his defamation, the court will not accept. Why? Because prima facie, the court finds that only two persons are there in the room. There is no third person. So if there are no other person in the room, this means defamation has not happened. Defamation has to be in the eyes of the substantial number of people. I mean, which means that the people start, people start thinking low about the person. But then there is nobody. So no defamation. But then if settings change, and if A and B are walking on the road, A says something, A abuses B, and there are 10, 20 people around who listens to that, then B has every right and evidence to bring a case of defamation against A. So what does it mean? If you are writing something about somebody on the social media and you are spreading to 50 people, you are in any way taking the risk of getting yourself involved in the defamation case. And that too, both civil as well as criminal. So, so what is the takeaway for you people? I mean, those who are in this session, you must be beware of writing any such thing against anybody who feels that he has been defamed by your writing. But mind it, if the person against whom you have written, if he does not bother, whatever you keep writing, you and lot of other people, if there is a politician, he does not care whatever is written against him by anybody on any platform, in mainstream media, on social media, this means no defamation has happened. Defamation has happened or not is something which is to be decided by the aggrieved party, right? So moving to the next slide. So, sorry, Ritik, to the back slide. Now, yeah, there are four explanations in which are in the previous slide. Four explanations, and there are 10 exceptions. Obviously, it is too difficult to go into all these details. In any case, I will provide the this slides, this PPT to you, so you can make out what amounts to defamation, what does not amount to defamation. But three, four things, summarily, I can tell you, like defamation can also happen of a deceased person. This means somebody has died, and after that, you write something against that person. The family members of that person can bring a defamation suit against you. So you should be cautious. Like a lot of things are written these days on social media against Rajiv Gandhi, against Jawaharlal Nehru. And if you get any such report and you are further forwarding that message, and there is any such thing in that message which, if Sonia Gandhi or the Rahul Gandhi, they take offense of and they decide to bring a defamation case against you, you will be trapped. So be cautious on such kind of things. And defamation is not only of an individual, it is also covering the associations, the societies, the group of people. So if you are writing against any institution, that can also amount to defamation. Say, for instance, if you write on the social media, in your post, in your tweet, you write that Congress is a party of is a party of the corrupt people, or if you write that RJD is a party wherein most of the people are criminal. Now, this, by doing this, you are getting yourself involved in criminal defamation. So beware of doing any such thing. Right now, a few more examples I would like to give you, interesting examples. As I said in the initial definition, that even if you are not saying anything, simply by your by certain symbols, you do something that can amount to defamation. Now, I give a very interesting example. Now, in a class, the watch of a student is stolen. Right now, the A's watch is stolen. A complains to the teacher that his watch has been stolen. Now, the teacher asks the entire class that who has taken A's watch. Nobody says anything, but few students start looking at B. This means B's defamation has happened. If B decides, he can bring a defamation suit against A. Against A, sorry, the B can bring a defamation suit against the persons who have uh, given a gesture to him in a suspicious manner, pointing thereby that as if B has stolen. So the defamation happens. But there is no defamation if the teacher is scolding a student in the class, right? So nobody can bring a defamation case against the teacher. Similarly, in the master-servant relationship, if there's a domestic help working in your house, if you give some order to her, him or her, and there is no compliance, and then you are scolding the domestic help, the help cannot bring a defamation case because that is, that's part of the exceptions, right? So these are the things. So I told you what all is covered, what all is not covered. As far as journalism is concerned, anything which is which if you're a writer, if you're a performer, you do something knowing fully well that it is going in the public domain, anybody might be reading it. You would have written a book. If you are performing something on a stage, you know that if it is a ticketed show, anybody can buy a ticket and can come to the auditorium, can watch your show, and then after watching your show somebody says that you are a bad actor, you do not know acting, you can never bring a defamation case against that person. But there is a thin line. Now if for somebody, like if a film is being reviewed and the reviewer says that this film is not good, and the reviewer is critical of the film, but at the same time he writes that this director has no knowledge of the filmmaking, all his films are bad and he does not know how to make a film, then in that case, if the director decides, he can bring a defamation case against him. So the criticism should pertain only to that thing which is which has been presented in the public domain of that person, nothing beyond that. Moving on. So all these exceptions mostly I explained. You can go through once the PPT is in your hand. Most of the things are covered. And as far as the punishment is concerned, just backslide, Ritik. The punishment is covered under 500, 501, 502. But then again, defamation is a law wherein if somebody is bringing a defamation suit against you, the intention is mostly not to put you into much trouble. Simply, it is spontaneous. Uh, so that is how courts also do not take the defamation cases very seriously, and no harsh, the worst punishment that can be given to a person who has taken away somebody's freedom and who has violated the defamation law is 2 years, and the monetary punishment is very, very less. Now, moving on to another law, which is okay, I can tell you the next slide. Yeah, there are two very important cases, and this case is very interesting. Mind it, this Arvind Kejriwal, who was the chief minister, who is the chief minister of UP, he was reading out from a list in a public meeting that these are the corrupt politicians, and he also read out the name of Nitin Gadkari, who is a tall leader of BJP, who was also the president of BJP, and then he brought a case, criminal case, mind it, criminal case, criminal defamation against Kejriwal. And there was a, he was, the Arvind Kejriwal was about to be arrested, but then he got relief from the Supreme Court, and that is how he could save. Later on, Arvind Kejriwal expressed regret for whatever he had said about Nitin Gadkari, and then Nitin Gadkari withdrew the case from the court. Another case is next slide, Ritik. Another case is this about this Jain Commission. Jain Commission was set up to investigate into the conspiracy angle in the assassination of Rajiv Gandhi. During the proceedings of this Jain Commission, Subramaniam Swamy, who is a senior leader of BJP and who is always in news for his controversial remark, he made a remark against Ram Jethmalani, who is a very, very senior criminal lawyer and a politician in the country. So he made some remark, which was that this Ram Jethmalani was accepting funds from LTTE, which is Tamil Liberation Tiger, the terrorist organization of Sri Lanka. So Ram Jethmalani brought a defamation case against him. Finally, the case was decided against Subramaniam Swamy, and since this was a civil defamation case, so a fine of 5 lakh rupees was imposed on Subramaniam Swamy. Now moving on, next slide, Ritik. sedition. Now, sedition is not directly covered under Article 19.2, but in a way it is part of a provision, restriction, which is there under Article 19.2, which is sovereignty and integrity of the country, integrity of India. But otherwise, sedition is a law which is part of the criminal law. In Indian Penal Code, which is the criminal law of the country, there is a provision, this 124A. The Indian Penal Code, it is interesting to note that, I mean, for all those who have no idea about the criminal law and all, so this is the first code, Indian Penal Code, which was made in 1860 by the then British government in India. And originally, there was no provision of sedition. In the year 1870, this provision was added, and that is how the provision for sedition is under 124A. Now, if you look into the definition, now this is a very ambiguous definition. There's no clarity, and that is how there is always controversy on the imposition of 124A in the country, and this is again a law. Like contempt of court, like defamation, this is again a law which is mostly used by senior people, by important people to take revenge from their opponents. So, and this is a law which is hardly in 3 or 4 countries in the world. Earlier, this law was there even in Britain when Britain was ruling India, but they have also scrapped this law. And interestingly, we have not only continued with this law, we are, I mean, we means the government, central government, or any other state government, irrespective of political parties, which was in power or which is in power, they slap sedition law against their opponents to settle scores with them. So, I mean, for young people must understand this by these examples, the kind of legal system that we have in our country. Lot of such laws exist in our country, which are against that very freedom which I talked about initially, that the freedom of speech and expression, Article 19.1A. And defamation law is in a way coming in the way of freedom of speech and expression. Same is with contempt of court, same is with sedition. And there have been instances, those who read a newspaper or those who follow news must be understanding this. Every now and then something is happening, then there is a sedition law is slapped on somebody. Okay, moving on to the next slide. As per there are certain cases, if I can tell you about sedition, because sedition is wherein you are showing disrespect to the state. Disrespect means you are making some such statement which might be inciting the people to be up in arms against the existing regime, or you are making any such statement which is inviting hatred, which is inviting contempt, which is inviting disaffection against the government, against the regime, then that may amount to sedition. Whether that is sedition or not, there are a lot of judgments made by the high courts and the Supreme Court, and many judgments are contradictory in nature. In case the Supreme Court would have said that this sedition law has been placed properly, in some other case they will set aside the sedition charges. And if you look into the statistics, you will find that most of the sedition cases, they do not stand the judicial scrutiny, and most of the people against whom the sedition charges are brought by the government, any government, mind it, irrespective of the political party, the charges do not stand in the court. But then why these charges are made? Because even if suppose if the government slaps some sedition charge against somebody, against any politician of the opposition party. Now, even after 3 years or 4 years, that person is the charges are set aside by the court, and that person is acquitted. But the purpose, the objective of the government is fulfilled, because that person remained disturbed for 3 or 4 years. So that is how I'm saying this, that this is a charge which is normally misused by the establishment. Next slide. There are two very interesting cases, Lokmanya Tilak and Mahatma Gandhi. Lokmanya Tilak was taking out two newspapers, Maratha and Kesari. He wrote articles against the then British regime, and the British government took offense to that, and he was arrested under the sedition charges, and finally he had to serve 18 months in jail under sedition charges, and this thus became the first case wherein somebody had to serve imprisonment for his writing. So now mind it, since this law is very much in existence, so any journalist can be trapped under this. If the government does not feel comfortable with the writing of a channel, of a news organization, of a newspaper, of a journalist, easily the sedition charges can be slapped. Or if you are not a journalist, journalist in the sense that you are not a full-time worker, a full-time journalist working in a news organization, but then you keep on writing on the digital platform. You keep on writing, making your tweets. You are writing on the Facebook. You are writing something, a piece, and then you are sending it through your WhatsApp to a lot of people. So might be, be careful. You might be involved under sedition. Now, I told you about the legal status, whether it's right or wrong. Law should be there, should not be there. It's a very long debate. But you have to be cautious of this. Mahatma Gandhi was also imprisonment, sent for on imprisonment for 6 years, though then British government decided to release him. Moving on to the next slide. Okay, now what is incitement, what is not? This is very difficult. Obviously, I cannot explain it in 2 or 3 minutes. I will simply take 1 minute, something I have written in the slides, which you can go through, or at your level, you can try to gather more information on this aspect. Now, if I will tell you one very small thing, and I am tracing it to number of judgments of the Supreme Court. So taking a clue from those judgments, I give you an illustration to explain this. If you say this, that this existing government at the center is incompetent, is corrupt, is not delivering justice to the people, not doing any good to the common people, you might be interpreted by the government that you are inciting the people. If you say, along with this, that this is an unjust government, it should be uprooted. This might be insightful according to the government, and they can bring a sedition charge against you. But then, going by the Supreme Court judgment, we find that this does not amount to incitement. This does not amount to sedition, for the simple reason that whatever I said, whatever I wrote, calling upon the people to oppose this government, to uproot this government, nobody acted. Nobody acted on my provocation. Nobody acted on my incitement. If this happens, this means sedition has not happened. Merely saying something does not amount to sedition. But if I make this call and there are 1,000 people on the streets, then obviously there can be a sedition charge brought against me. So there's a very thin line, and this is always happening. The government brings, like we can have this Kanhaiya, next slide, Kanhaiya Kumar case is there. And I mean, so many cases are there. Kanhaiya Kumar is a very, I mean, latest than there's a cartoonist, Amit Trivedi, that case is there. He made some cartoon which the government did not like. So even in these cases, the violation of the sedition law can happen. But then what I can tell you at this point, that you must be cautious. You must be cautious in your expression, in your writings. Yeah, the previous slide. This one very important case. This case was filed in the Supreme Court by Shreya Singhal. And mind it, since whatever we are doing in the on the digital media or on the social media, one very important law which comes always in the picture, which is Information Technology Act. Yesterday, Ritik Ghosh also referred to this act, and there's a provision, very important provision, used to be a very important provision in this act, which is 66A. 66. Now, this 66A has been scrapped by the Supreme Court. So, this is no more part of the law. But still, the police, there have been many reports that police is still arresting the people under 66A, which is completely wrong. And that is where you all, we all must understand the laws. If we are very active on the social media and we do not know what is there in IT Act, then unknowingly we might be trapped in some violation, and then we have to face the consequences. We have to face the music of that. And now 66, let me make it clear. Now, after this provision has been scrapped from the IT Act, merely forwarding some message will not will not put you under serious trouble. There has to be something more to that. There has to be something more to that. So like this Shreya Singhal, she was a law student, and she shared some post on the Facebook and about this Azam Khan, who was a minister in UP. Azam Khan brought a case against her in a police under 66A. She went to the Supreme Court, and the Supreme Court said that simply making some remark on the social media does not amount to any criminal act, and that is how this section 66A does not stand the judicial scrutiny, and it has to be abolished. Next slide. Okay, so I'm not going in many more cases. So moving on to the final thing, final law. Yeah, just final thing you can go through. I told you about Asim Trivedi's case. Binayak Sen case is the biggest case as far as a sedition is concerned. He's a medical practitioner, but he was arrested on the charge of sedition. And the charge was that he was supporting and helping the Naxalites in the state of Chhattisgarh. Whereas the truth was that he was taking care of the families of those Naxalites who were booked under different charges, and he was providing medical aid to the family members, and he was running some schools, etc., to make sure that the children of these Naxalites, they get education. But then the government interpreted in their own way, and he had to serve imprisonment because of the charge that he was involved in the seditious activities. Yeah, moving on, the final act I will talk about, that is copyright. So since there is no time available, I will finish it up in maximum 5 minutes. Now, copyright is a law. Copyright is a right on your creativity. Creativity means anything that we do, any poem that we write, any novel that we write, any sculpture piece that we design, any graphics that we do, any song that we sing, and any such thing. This is a creative work, and this is covered under copyright. So there is a law for this, that's Copyright Act, and your right on your creativity is protected under Copyright Act, right? Next slide. In India, as I said, there is a law, that's Copyright Act 1957. This act has been defined. So whenever we are looking at any act, we have to look at the provisions of the act along with the amendments which are there. This is also an act of the British era. And here I must tell you, because earlier also I told you about defamation, contempt of court, all these laws were initiated during the British period. And since British government was an alien rule, was a foreign government, they were bringing all kind of acts to suppress the Indians. So ideally, the thing should have been that all these laws should have been scrapped or should have been amended. Unfortunately, that has not happened, and still we are continuing with so many repressive laws. Now, as far as the copyright is concerned, now copyright is a law which is basically part of intellectual property right. Intellectual property right can be broadly divided into two areas. One is the creative rights, which are covered under copyright. On the other hand, there are the business rights or the trade-related rights, which is called TRIPS. So other laws means like the patent, the brands, all this is covered under the trade-related rights. So here I will be talking about the creative rights. So creative, as I said, the anybody who is a composer, who is a film producer, who is a novelist, who is an author, in fact, has the copyright. Next slide. And mind it, copyright is a legal right. At the same time, it is a natural right. It is a legal right in the sense because there is a law, and anything that you do, you can get yourself registered. So you have a legal right on something that you have created. On the other hand, it is a natural right in the sense that even if you would not have got your work registered, even then you have the right. Like if you are a student, you are sitting in your class and in the recess time you wrote a poem. You wrote a poem. You did not go for the registration of your poem. You did not get a copyright officially, legally, but merely by writing a poem, you become the author and you enjoy your copyright on your poem. Nobody can take it away. Nobody can get your poem published in his or her name, because if that happens, that will be a violation of your copyright. Next slide. Okay, so what are the rights of an author? The right is that nobody can take away your creativity without your permission, right? This means if you have written a story, somebody wants to make a film on your story, on your novel, that person has to approach you. You will sell your copyright to that person. So you can give it partially, you can give it fully in return of some money, or you can even do it for free. And then that person can use your creative piece for making a film. But then there has to be an agreement to this effect between the copyright holder and one who is buying your creativity. And nothing beyond can be like if you give your story to a filmmaker for making a film, and then you and that filmmaker took your story for making a film in Hindi. Tomorrow he is getting the film dubbed in 10 different languages. If that is not part of the copyright agreement, that will be a violation. And you can bring that filmmaker to courts asking him to pay for the violation of your copyright and for the commercial use that he has done of your creativity. Next slide. Okay, so a lot of things are there. As I'm saying, something is sale on hire. But then I give you one more example. If you are working as an employee in a news channel or newspaper, and whatever reporting you are doing, that the copyright owner is your employer. So you do not have a copyright. आप ये नहीं कर सकते. Suppose that you are working in a newspaper and you are a reporter and you are an investigative journalist. You have done some investigative journalism, and then all that has been published, all that has been broadcast. After a few years, you quit the job, and all your story you get published in the form of a book. This will be a violation because you are doing this with the stuff on which you do not have a copyright. Next slide. Now, as far as the time is concerned, any author or creator has the copyright during his or her lifetime, and then 60 years after his or her death. And that time, the copyright is enjoyed by the family member of yours. So that is all about the copyright. Now, so I finish my lecture with this. So I've covered too many things, I understand, but I try to give you as much clarity as possible. If something is not understood, or if you have certain questions or queries, then you are welcome. I will be happy to answer that.
Yes, sir, we have a lot of questions. So, sir, there's one question from Shreya Rohatagi, and she's saying the recent Prashant Bhushan case is also a case of contempt of court. Sir,
Yeah.
is it criminal contempt?
Yeah, it's a criminal contempt case because it was brought with the intention to send him to jail. The people who are not comfortable with the kind of activism that Prashant Bhushan does, they wanted to teach a lesson to Prashant Bhushan. So that is how a case was brought against him, and the intention was to bring him to jail. What does it mean? Even if that would have been for a small period, that would have amounted to the cancellation of registration of Prashant Bhushan as a lawyer, right? So this is what I have been telling you in respect of all the cases. All these laws, which I told you, except the copyright, all these laws are there to settle scores. And only the powerful people settle scores with another powerful person or within powerful institution. So it's always a misuse because whatever Prashant Bhushan said in his tweet, that was not defamatory, that was not seditious. Because I told you a number of things. There can be always two interpretation of the same statement. The government is saying that this amounts to sedition, and then the court says after a few years of the trial that this does not amount to sedition. In most of the sedition cases, almost all sedition cases, the person on whom the charge was slapped is freed, is acquitted by the court. This means charges are always framed with a malice intention, and government always does it. And when I say government, I should clarify every time that I am talking about the establishment. Whosoever is sitting in power, A party or B party, but the nature of the establishment is such that no government always like its criticism. And if there are some big critics, they want to teach them a lesson so that other people don't dare to criticize. That's the objective of the government in all such cases. Yeah.
We have a related question to this case only by Siddhant Bhatia, and he's asking why was Prashant Bhushan only fined 1 rupees?
I told you about contempt of court, civil contempt and criminal contempt. I think प्रशांत भूषण के खिलाफ दोनों था, सिविल कंटेम्प्ट भी था, क्रिमिनल बहुत सारे जो आई एक्सप्लेन यू दैट कि कंटेम्प्ट में भी डिफेमेशन में भी दोनों में सिविल और क्रिमिनल है. और contempt of court में I explained there is a very thin line between civil and contempt. Similarly, in defamation also there is a thin line between civil and criminal. क्रिमिनल केस जो भी लाता है वो इसलिए लाता है कि वो जिससे बदला लेना है उसको जेल भेजना चाहता है, ठीक है, उसको ठिकाने लगाना चाहता है, टू सेटल द स्कोर्स. और जिसको पैसा लेना होता है तो वो पैसा ले लेता है. अब 1 रुपये का फाइन अरुंधति रॉय को भी एक दिन के लिए जेल भेजा. आई टोल्ड यू अबाउट दैट केस. कल्याण सिंह को भी एक दिन के लिए जेल भेजा. तो उनको जेल भेजना इरादा नहीं था, उनको ये बताना था, जुडिशरी उनको ये बताना चाहती थी that we have the powers to punish you. So that is symbolic. The Supreme Court wanted this to tell to Prashant Bhushan and others like him that if you don't mend ways and if you don't abide by what we are saying, we can send you to jail, we can fine you because you have committed a mistake. So this is basically contempt of court जो law है, this has been legislated to establish, to reinforce the authority of the judiciary. That's सुप्रीम कोर्ट को सजा देने का ये था, उनको ये बताना था कि हम सुप्रीम कोर्ट हैं और हम कर सकते हैं ऐसा. That was the objective. Civil contempt में normally punishment is always symbolic.
Yes, sir. So then we have another question by Samriddhi Shukla, and she's asking, if we base our work or receive inspiration from someone else's work, what should we do not to violate copyright laws?
You have to take permission from that person. You have to take permission, and it's not difficult. If you're doing some good work for the society, for the betterment of the people, for the betterment of mankind, normally people will allow you, right? जैसे playwrights है, तुमने everybody would have seen, colleges में भी देखा होगा, school में भी सारे बच्चे कुछ ना कुछ theater करते होंगे. तो अगर तुमने किसी established playwright का play उठा लिया और तुमने उसको कर लिया, तो अगर स्कूल के अंदर किया है तो no violation will happen for the simple reason that fair use का provision है. कॉपीराइट में फेयर यूज का प्रोविजन है. सपोज आपने बहुत एस्टेब्लिश प्ले राइट का प्ले उठाया और अपने स्कूल में उसको स्टेज पे कर लिया, यू हैव नो कमर्शियल एंगल इन्वॉल्व्ड एंड यू डू नॉट हैव द इंटेंशन कि आप प्ले राइट को स्पेस नहीं दे रहे हैं या उसको, आपका है कि एक एजुकेशनल पर्पस है. सो एजुकेशनल पर्पस इज कवर्ड अंडर फेयर यूज. सो यू नीड नॉट टू टेक परमिशन ऑफ द प्ले राइट एंड यू आर नॉट वायलेटिंग द कॉपीराइट एक्ट. बट इफ यू प्रिपेयर ए प्ले इन योर स्कूल और उसके बाद आपने सोचा या आपके स्कूल ने सोचा कि बहुत अच्छा ये नाटक तैयार हुआ है, तो चल के इसको श्री राम सेंटर में भी एक शो कर देते हैं, एक शो ले जाके बॉम्बे में भी कर देते हैं, तो स्टूडेंट्स को थोड़ा एक्सपोजर मिलेगा. इफ यू आर डूइंग दिस and if you are doing this without taking permission of the playwright, then you will be involved in the violation of Copyright Act.
So we have a similar question. I think we have an artist amongst us. So he's asking that I'm an artist, and if any bigger artist stole my artwork and put his name on it and sell to people, will I be able to do something against him?
Yeah, you have to file a civil suit against that person. राइट और बहुत आसान तरीका बता देता हूं मैं अपने कॉपीराइट वर्क को, अपने क्रिएटिव वर्क को प्रोटेक्ट करने का. आपका नेचुरल राइट हो गया. सपोज मैं एक उदाहरण देता हूं, बहुत आसानी से समझ में आ जाएगा. सपोज किसी ने कुछ लिखा, एनीथिंग दैट यू वुड हैव रिटन, और अपने घर पे रख लिया. 5 साल बाद उसने देखा कि उसने उसी के ऊपर बुक छाप दी अपने नाम से, जबकि उसका हैंड रिटन पीस उसके पास रखा हुआ है. You can file a case and you can easily win the case by presenting your manuscript in the court. आपके पास manuscript है, मतलब कॉपीराइट आपका है. तो आपने कहीं नहीं छापा, कोई बुक में नहीं छापा, किसी को नहीं दिया, आपने घर पे रख लिया, लेकिन नेचुरल राइट है आपका. जैसे ही आपने क्रिएट किया, as soon as you create something, you acquire a copyright, even if you are not getting it registered, right? तो वह manuscript से होगा. बट देन ये पुरानी बात थी, ये आसान तरीका आज भी है लेकिन पुरानी बात है, क्योंकि आपको ये हाथ से तो लिखता नहीं है मोस्टली. जब से डिजिटल एज आई है, आप तो सीधा कंप्यूटर पे लिख रहे हैं और अपनी फाइल सेव कर ले रहे हैं. लेकिन अगर आपने कंप्यूटर में लिखा और अपनी फाइल सेव की और किसी ने कैसे भी मार दी आपकी कॉपी और उसको छाप दिया या मिसयूज कर लिया, आप कोर्ट में जाएंगे, आप उसको प्रेजेंट करेंगे, दिस फाइल वाज सेव्ड ऑन सच एंड सच डेट एट सच एंड सच टाइम. और वो जब बुक छपी उससे 2 साल पहले की डेट है. यू कैन ऑलवेज विन द केस इजीली, इवन इफ आपने उसको रजिस्टर नहीं करा है. एक और तरीका और आसान सा तरीका बताता हूँ, जो सबसे आसान था, सबको करना चाहिए. जैसे ही आप कुछ लिखें और आपको ये लगे कि ये तो मेरी चीज है, कोई इसको चोरी ना कर ले, आप हमेशा उसको खुद को मेल कर लीजिए, अटैचमेंट लगाइए और अपने को आप मेल कर लीजिए. वो कॉपीराइट रजिस्ट्रेशन से भी पुख्ता आपका हो गया, क्योंकि आपने खुद को मेल कर लिया, आपके पास डिजिटल प्रमाण है कि वो आप ही का पीस है, आप ही की क्रिएटिविटी है। कुछ मत करिए, ये तो सभी लोग कर सकते हैं। अटैचमेंट लगा के खुद को मेल कर लीजिए, यू आर प्रोटेक्टेड।
Yes, sir. So we have another question by Avnish Chabra,
Hmm.
and he's asking that judiciary is supposed to handle all disputes and cases, but the number of people working in judicial department are much lesser than the number of cases. Why are lesser people interested in?
इसका जवाब तो मेरे पास भी नहीं है, मैं भी इसका जवाब ढूंढ रहा हूँ। इसका जवाब है, एक लाइन का जवाब यह है, अब चूंकि ये जो स्टूडेंट है ये हमेशा ही सवाल करता है, तो इसकी वो मैं पर्सनल एडवाइस भी कर सकता हूँ कि इसके लिए ये समझना पड़ेगा कि हम किस तरह के पॉलिटिकल सिस्टम में रह रहे हैं, किस तरह की गवर्नेंस है हमारी, कैसा हमारा जुडिशियल सिस्टम है। और ये थोड़ा हार्श हो सकता है, बट आई वुड लाइक टू टेल दिस कि वी आर डिस्पाइट सच ए गुड कॉन्स्टिट्यूशन दैट वी हैव, आई बिलीव दैट वी हैव द बेस्ट कॉन्स्टिट्यूशन इन द वर्ल्ड, जिसकी वजह से हम लोग बचे हुए हैं 70 साल तक। हमारे सारे नेबर्स में अप्स डाउन से गुजरे हैं, हम अभी भी इंटैक्ट हैं डेस्पाइट ऑल काइंड ऑफ प्रॉब्लम, वो कॉन्स्टिट्यूशन की वजह से है। लेकिन कॉन्स्टिट्यूशन को जो इम्प्लीमेंट करने वाले हैं 70 साल से जो लोग पावर में बैठे हुए, दे हैव नॉट अलाउड दिस कंट्री टू रिफॉर्म deliberate. I mean, this is, I mean, I'm saying this with the responsibility. All those people who have been governing us for the last 70 years, they have ensured that we do not progress, we do not move forward. इसीलिए हमने आज तो कोई जुडिशियल रिफॉर्म्स नहीं किए, कोई भी पार्टी आ जाए पावर में, द लास्ट थिंग any government will think of is the legal and judicial reforms. लॉ कमीशन की रिपोर्ट्स आती है, वो धूल खाती रहती है, कोई रिफॉर्म नहीं होता। जजेस ही नहीं है, कोर्ट्स ही नहीं है। मैंने सारा लॉ तो बता दिया, ऑब्वियसली मुझे लॉ बताना था, इससे ज्यादा मेरा मैंडेट है नहीं, मैं रिफॉर्म तो कर नहीं सकता। आई एम नॉट ए पॉलिसी मेकर, आई एम नॉट पार्ट ऑफ द गवर्नेंस, एंड दिस इज ए सैड स्टोरी। एक डिफेमेशन का केस लोअर कोर्ट में मिनिमम 10 साल चलता है, मिनिमम 10 साल, ठीक है। उसके बाद अगर अपोजिट पार्टी जिसके खिलाफ अगर जजमेंट आ गया, मैंने फाइल किया, मैं जीत गया, जिसके खिलाफ किया हार गया, वो हाई कोर्ट जाएगा, another 10 years। तो कभी भी आपका डिफेमेशन का केस 20 से 25 साल से पहले नहीं तय होगा। दिस टेल्स द होल स्टोरी। और ये 1950 से 2020 तक ऐसा ही है, इसमें कोई चेंज आया नहीं है। कोर्ट कहता है हमारे पास टाइम ही नहीं है, आप अपने डिफेमेशन के लिए लड़ रहे हैं, वी हैव मोर इंपॉर्टेंट केसेस टू हैंडल, तो वो एक बार में आपकी तारीख 6-8 महीने की लगाएगा, तो 10 साल में 10 ही तारीख मिलेंगी आपको। तो ऐसा देश जो इतना गरीब है, ऐसा देश जहाँ की मेजॉरिटी पॉपुलेशन बिलो पॉवर्टी लाइन है, ऐसे देश में किसी का जब किसी के पास खाने को ही नहीं है, तो वो उसका सम्मान कहाँ से सुरक्षित रहेगा। तो हमारे तो जो 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 डिफेमेशन का लॉ वेस्ट के पैरामीटर्स पे बना है, वहां पर जहाँ लोग बहुत सेंसिटिव हैं, यहाँ तो हमारी सोसाइटी ऐसी है कि हमें कोई फर्क ही नहीं पड़ता, कोई किसी को गाली देता रहे, हमारे तो सारी गालियां हमारी भाषा में इस्तेमाल होती हैं, वी डोंट माइंड, ना तो हम गाली सुनने में हमें प्रॉब्लम है, ना देने में प्रॉब्लम है। तो वी आर लिविंग इन ए सोसाइटी वेयर इन डिफेमेशन लॉ अपीयर्स टू बी ऑफ नो यूज। What I told about this because I was supposed to tell this, one, two, even if it is not properly implemented, even if it is not of any use in our society, but we must know it, because unknowingly we may put ourselves to trouble sometime. तो इसलिए लॉ जानना तो जरूरी है, लेकिन उसके साथ ये सही है जो इसने सवाल उठाया, और हम सभी उसको फेस कर रहे हैं। बट नो पॉलिटिकल पार्टी, इलेक्शन में देख लो, इलेक्शन में किसी का नहीं होता पार्टी का कि हम जुडिशियल रिफॉर्म लाएंगे। आज तक किसी पॉलिटिकल पार्टी ने चुनाव लड़ा इस पे कि हम लीगल जुडिशियल रिफॉर्म लाने वाले हैं, ना वोटर कभी पूछता है। तो ये ऐसे ही चल रहा है, और ये जो अभी 17-18 साल के लोग हैं, ये भी अगले 30 साल तक देखेंगे कि ऐसे ही चलेगा, फिर अगली जनरेशन भी यही देखेगी। This system is not going to be changed till the time there is a radical change in our system of governance.
Over to you, Dr. Asha.
सर, आई thoroughly enjoyed your session. मुझे बहुत बेहतरीन लगा और मुझे कई सारी नई जानकारियाँ मिली. In fact, if I am allowed, can I ask one question? I
Yeah,
have
yeah,
one question.
sure, sure.
Actually, my question is related to Copyright Act. अगर हम Google Drive में अपना कोई काम, अपना कोई research paper सेव करते हैं, खुद को
हाँ,
मेल नहीं करते हैं, तो भी
हम्म।
तो वो सुरक्षित होगा
हाँ,
क्योंकि
वो भी
उसमें
सुन,
डेट ऑफ
एग्जैक्टली
एग्जैक्ट.
एग्जैक्टली, कभी सुन।
ओके.
हालांकि हालांकि
ओके.
कॉपीराइट लेने में भी कोई दिक्कत नहीं है, अब तो ऑनलाइन है। तो पहले
हम्म.
लंबा था, कम्बरसम था फिजिकल फॉर्म में, बट अब तो
हम्म.
ऑनलाइन अप्लाई कर दीजिए। ऑनलाइन अप्लाई करने के बाद आपने जो एप्लीकेशन दी होगी, आपका जो पीस है जो क्रिएटिव, वो फॉर ए मंथ और सो दैट विल बी कैप्ट बाय द दिस कॉपीराइट बोर्ड इन द पब्लिक डोमेन। और ये वो कहेगा कि किसी को कोई ऑब्जेक्शन तो नहीं हो सकता है, आपने कॉपीराइट के लिए अप्लाई किया हो लेकिन आपने ही कहीं से चुराया हो। तो
एग्जैक्टली.
इसलिए वो वहां रखेंगे, ऑब्जेक्शंस इनवाइट करते हैं, कोई ऑब्जेक्शन नहीं आता है तभी आपको आपके पीस, आपकी क्रिएटिविटी पे आपका कॉपीराइट मिलेगा।
Exactly. Thank you. Thank you. So I seriously enjoyed and I was reminded of so many things while listening to you. In fact, recently I saw a Netflix film, Little Women, in which one of the authors, she is basically negotiating with the publisher. She is a female author और काफी पहले पुराने जमाने की वो महिला है, यूरोपियन महिला है और वो फीमेल ऑथर डायरेक्टर से कहती है, सॉरी पब्लिशर से कहती है कि कॉपीराइट क्या होता है. तो पब्लिशर ने समझाया कि हम आपका काम खरीद लेंगे और उसके बाद हम उसको जैसे चाहे इस्तेमाल कर सकते हैं. तो ये ऑथर ने उनको जवाब दिया कि आप मैं कॉपीराइट मैं रखूंगी, पैसे आप रख लीजिए. तो बेहतरीन मुझे आपका प्रेजेंटेशन लगा,
नहीं नहीं,
स्पेशली.
इसमें 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 आशा जी
जी.
कई तरह के
जी.
प्रोविजंस हैं।
जी.
एक तो ये है कि अगर मैंने कोई बुक लिखी है और मैंने अपना कॉपीराइट बेच दिया ऑथर को, तो
जी.
ये वन टाइम एग्रीमेंट होगा, वन टाइम पेमेंट होगा। मैंने 50,000 रुपए ले लिए और बुक उसको दे दी। अब वो बुक छापेगा तो मेरे ही नाम से, ऐसा नहीं अपने नाम से छाप लेगा, लेकिन कितनी कॉपी छापेगा, कितनी लैंग्वेजेस में छापेगा, कहाँ ट्रांसलेट करा लेगा, कहाँ बेचेगा, उसका आउटलुक है। वो 50,000 मुझे देके हो सकता है 5 लाख कमा ले उस बुक से। तो
जी.
ये उस केस में होगा जहां मैं अपना फुल कॉपीराइट उसको दे रहा हूँ।
जी.
सपोज मैंने कहा कि मैं जो कॉपीराइट दे रहा हूँ वो पार्शियल है, मतलब copyright will be shared by the author and the publisher pertaining to that book that has been published by the publisher. Suppose publisher की ने बुक छापी और मैंने कहा कि ये 5 साल के लिए, 5 साल के बाद फिर that publisher is not allowed to reprint that book, और मैंने फिर वही अपनी बुक थोड़ा चेंज किया, दूसरे पब्लिशर को दे दी, उससे भी पैसा ले लिया। आई कैन ऑलवेज डू इट बिकॉज आई हैव नॉट सोल्ड द कंप्लीट कॉपीराइट ऑन माय बुक। तो दोनों तरह के हैं प्रोविजंस है। फुल कॉपीराइट भी बेचा जा सकता है, और अगर मैंने फुल कॉपीराइट नहीं बेचा है, ऑथर और पब्लिशर दोनों शेयर कर रहे हैं कॉपीराइट, उस केस में ये वन टाइम पेमेंट नहीं मिलेगा। उस केस में मुझे रॉयल्टी मिलेगी, which is a certain percentage on the cover price of the book.
ओके. ओके.
Which is certain percentage on the cover price of the book. तो वो फिर मुझे जब तक वो बुक बेचेगा तब तक वो करता रहेगा। मैंने अगर 10 साल पहले जैसे मैंने किताब लिखी थी, वो हर साल पब्लिशर मुझे पैसा चेक भेज देता है, जो उसकी बुक बिकती है उसका जो रॉयल्टी बनती है हर साल। तो मैंने उसको कॉपीराइट नहीं बेचा, तो 10 साल से वो हर साल मुझे रॉयल्टी दे रहा है और अगले 10 साल तक देता रहेगा। तो अगर मैंने बेच दिया होता, फिर मुझे वन टाइम पेमेंट मिला होता, फिर वो चाहे जितना पैसा कमाता, मुझे एक पैसा नहीं मिलता।
Okay, okay. Thank you so much. Thank you so much. And also quite balanced presentation it was, because we had examples from all kind of eras, and it was not tilted towards any kind of government. It appeared to be fair, objective and balanced, and I'm really happy and glad to be part of this session. So I'm uh, thankful to you. And to conclude, I would ask Yashashrika ji to take over. Thank you.
Sure, ma'am. Sure. Thank you, Dr. Amrish Saxena, for this enriching and insightful session. We learned about the importance of using our voice, but with reasonable restrictions. And understanding of defamation, contempt of court, and copyright is extremely important so that we use our voice responsibly. As was expected from you, sir, you used a lot of media-related examples, which I'm sure help students learn difficult concepts easily. Students, I would like to inform you that this is our second last session of media literacy course. From 29th onwards, we will share with you the Google form for evaluation. The evaluation will be on the basic concepts of that you have learned during this course. For your understanding, I will share with you the presentation and you can view the lectures on our official YouTube channel, DME TV. I would like to thank Dr. Asha for her constant contribution in the coordination for this course, Professor Ujjwal Chaudhary and Dr. Amrish Saxena for their constant guidance. The next lecture will take place on Wednesday, 28th October 2020, tomorrow. You will learn about the importance of privacy, how to safeguard your privacy, and respecting others' privacy. Very relevant, particularly when we witness the media circus during the Sushant Singh Rajput case. The webinar will be conducted by Ms. Shifali Chibbar, Assistant Professor, DME Media School. Come prepared with question. It is your last chance to ask relevant questions. Thank you. See you tomorrow.